Good afternoon, everybody. My name is Chris Justice, and I am here today again to join you in hopefully answering as many of your employment law related questions as I possibly can. As it's noted down below, I'm an employment lawyer with Samfiru, Tumarkin, and I practice out of its Toronto offices. So regardless, whether you're from Toronto, Vancouver, Calgary, wherever you may be, please get your questions in. And as I say, I'll do my best to answer as many as possible within the time that I have today. I wanted to start, of course, as I always do, as we always do, with some general topics, some opening topics to discuss before some of your questions come in. And first, I wanted to start actually with the news that's been around in terms of there being a lot of layoffs recently, a lot of terminations happening at various companies. One of the more recent ones is Napoleon, who are well known for making sort of barbecues, that type of industry. And then we've got Ubisoft as well, who had mass layoffs or mass terminations going on too. So whether you're with either of these companies or not, if you find yourself in a position where you are being let go, maybe it's because of a restructure, maybe you're being told that there's a shortage of work, whatever the reason may be. If your employer is letting you go and you're being provided with some sort of a severance package, before you sign anything or agree to anything whatsoever, you want to give us a call. You want to make sure that you receive the proper advice, because you may think that the severance package your employer is offering you is fair and reasonable, and that it does account for all the years of service that you've put into the company. But most often, in fact, the vast majority of times, whatever the package that is being offered to you, whatever it ends up being, it's not likely going to be enough. So you want to give us a call before you sign anything. If you're someone who's been let go or lost their job due to work shortages, restructuring, something due to COVID potentially, so that you fully appreciate what your entitlements are. Because if you're living in this country and you're an employee of this country and you lose your job, you can potentially get as much as 2 years of severance on top of other potential compensation amounts, depending on what your case exactly involves. So I figured it's always good just to remind people that their entitlements are likely much greater than what's being offered to them at termination. And that, again, we're finding ourselves in a time where a lot of people are being let go. So definitely give us a shout if you've been let go, and we'll take everything from there to make sure that you get what's fair and reasonably owed and coming your way. Another topic I wanted to sort of touch on before we get into some of the questions has to do with the issue of constructive dismissal. I know that a lot of people may already be familiar with the term constructive dismissal, but for those that aren't, constructive dismissal is essentially where there's been a significant change to the terms of your employment, something that's been normally imposed on you by your employer for whatever reason, without your consent. So this could take the form of a change in your job description. This could take the form in terms of where you're actually going to be working from a geographic standpoint of view. This could be a change to your compensation. This could be a change to your work hours. It literally could be any change to your employment. And if that change is significant enough, you need to understand that you have options at that point. So if you're being presented with a big change and you're sort of in the middle of your employment with a company, one thing you should do is tell your employer that you are going to review and consider the change. And in the meantime, get in touch with us, get in touch with the lawyer so that you can communicate to your employer in an appropriate manner in terms of dealing with that change. Because you may, if you're being presented with a big change to your employment, you may actually be willing to accept the change with or without additional conditions. Or you may simply be unagreeable to the change whatsoever, and you may want to tell your employer that that's not something you're agreeable to, and that you signed up to do a certain thing, and that's what you're going to do, but you're not going to do this these additional duties, or you're not going to accept this particular change. But before you actually object or push back with your employer on any changes to your employment, again, I think it's a best case scenario that you first involve legal counsel so that that certain things can be communicated in the appropriate fashion. But if you're an employee also, and you are being presented with changes, definitely don't feel like you necessarily have to accept those changes and continue working. A lot of times in my practice, I find that, I'm dealing with people who have already been subjected to changes during their working relationship. And maybe many months or many years have passed and their job has sort of morphed over time. And now they're coming to me, months or years later and telling me that, they don't want to agree to these changes anymore, that they, want to go back to what they were doing years before. And if they can't do that, that they want to get out, they want to get some sort of a severance package. And if somebody waits months or years while all of these changes are going on, it can make it a lot more difficult to then later on go back and, sort of say that you're no longer willing to do those things, or you're no longer willing to agree to those changes. So that's why it's very important when you're confronted with changes to your employment as an employee, that it be handled relatively quickly, that you don't stay silent and let those things go on, even if you're sort of objecting to them, because your continued employment might be considered you sort of accepting those changes. And all far too often, I find that people are agreeing to changes to their employment that maybe not are necessarily the biggest at the time, but slowly build up time after time after time and over time until it amounts to a massive change overall. And as I say, it may be too late to go back and change things. So you want to make sure you're being more proactive when it comes to this. You're consulting with a lawyer, you're getting advice, and that you're voicing your concerns. If you're not agreeable to doing a certain thing within the company, you want to make sure that you put on the record your objection. And again, this would come after speaking with legal counsel and getting some advice, but you want to make sure that you sort of have a record in place should you need to go back and rely on it in the future sometime. So yeah, if you're someone, again, who's been, or you feel as though you've been constructively dismissed because there are significant changes happening to your employment that you don't agree with, and you either have or you haven't yet discussed this with your employer, you need to contact us immediately so that we can take you through those steps and at least give you as many options as possible going forward, so that you're not, as I mentioned before, sort of negatively affected by your inaction previously. Having said that, I might get into a little bit more on constructive dismissal and sort of some of the things to do, or some of the things to be aware of or document as an employee while it's all going on. But I want to get to some questions, and I'll start with David Guido on YouTube. He's mentioning that he lives in BC, and he's asking if an employer is legally bound to follow a doctor's note. So it seems like David has given a doctor's note to his employer. He gave the employer the note on July 28th, and the employer asked him or his doctor to fill out a functional abilities form. And so then, sorry, David, I'm just reading along. You had it filled out, but you indicate that the doctor can't tell you what position would be good for you. And we don't, and I guess the company's saying we don't have to follow what the doctor says. So, David, I'm going to answer your question and sort of generalize it as well. I think it's important to talk about situations where an employee is medically incapable of performing some or all of their job, and when they're therefore looking for some accommodation to be made by their employer. So for your situation, David, you've got a doctor's note. I imagine the doctor's note says that you're incapable of doing your job to some degree. You provide that doctor's note to the employer, which I think was the right thing to do. You want to make sure that you're always communicating, or at least somewhat communicating on a regular basis with your employer about your medical status to some degree. Now, a common issue that comes up when it comes to people submitting doctor's notes is that the employer wants more information. You might give your employer a doctor's note that says, you need to be off work for this period of time, maybe for this reason. and your doctor, or sorry, your employer will come back and say, we want more information. We want to know this, 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 and this. They want to find out what your medications are like. They want to find out what your diagnosis is, what the actual diagnosis of your condition is. They want to know a lot of information. And the thing is that they're not entitled to this information, generally speaking. The only information generally that an employer needs to know as far as whether or not someone needs to be accommodated due to some sort of medical issue is the employer generally needs to know, number one, that there is an issue that's preventing the employee from working, and to have that ideally from a doctor. Number two, a general idea, if possible, as to how long the issue is going to last. So again, you don't have to give the diagnosis, but there needs to be, as best possible, some idea of how long you're going to need to be accommodated. So you may not be able to work at all for, let's say, 3 months, or maybe you are able to work, but you have to avoid lifting anything over 30 pounds. And that may be for a certain period of time. So generally the employer is entitled to know what the limitations or what the restrictions are for you to do that job or part of that job, and how long those restrictions or limitations are set to last. Now, you may not have an idea of how long the limitations are set to last, and that's fine. Your doctor will, I suppose, say that it's just something that needs to be assessed on an ongoing basis, and an update will be given. But that's generally the only info that you need to give to your employer, because that tells the employer how long you're off or need to be accommodated, and it tells your employer what your limitations or restrictions are. So that should be sufficient. And if you're an employee and you find yourself in a certain situation where you've given what you think is enough medical evidence or information to support your medical absence or to support your accommodation need, but you find that your employer is still asking you for a ton more information, don't assume that they're entitled to that information. Even if they want you to fill out a certain form, don't assume they're necessarily entitled to that information either. You want to get in touch with us first so that we can get a better understanding of what exactly the context is. Because sometimes when you're off work and you're looking to go back, or you can go back with limitations, your employer may have in place a short-term or a long-term disability policy, and maybe suggesting that you actually apply for disability benefits, which could replace your lost earnings. And that whole process has its own forms and its own sort of system to follow. But it's just to sort of illustrate the fact that there could be a number of different factors working at play when it comes to employees that are medically incapable of working or looking to go back. But David, going back to your question as well, if your employer has received a note from your doctor, and your doctor is explaining how you need to be accommodated, and your employer is saying that they don't need to follow what your doctor says, that's also a potentially big issue for the company, for the employer. Assuming that what your doctor is saying is fairly reasonable, modest accommodations, generally speaking, employers need to accommodate you to the best of their abilities. There needs to be a very extreme inconvenience and burden in trying to accommodate you, usually for an employer to say, we don't want to accommodate you, we don't have a position for you. So David, or anyone else who's listening, who's looking to maybe go back to work and they're being told that they can't be accommodated, or that there's no position for them to go back to, that's a potential constructive dismissal right there, that failure to accommodate. And that could potentially entitle you to a lot of severance, as well as involve human rights issues, in the sense that they're not accommodating a medical issue, presumably within a reasonable context. So David, there's potential huge amounts here that could be owed to you if your employer is not going to have you back, and if they're going to breach that fundamental obligation that they owe to you. So I would say get in touch with us, David. We can take down more information. We get more info from you, more documents from you, just to better understand everything. But what you're saying does sort of have that sense to me that, the employer could be in a lot of hot water, and that they'll either have to have you come back or risk potentially having to pay you, as I say, a lot of severance and other damages, including human rights stuff. But thank you for your question and sort of your current situation, letting everyone know. Moving on to some other questions. Thanks again, everyone, for your questions. I've got a question from Cuz on YouTube, who's asking whether or not a company can refuse short-term disability if this person was already diagnosed with a pre-existing condition after he started working for the company. And so first of all, Cuz, and anyone who's listening, if you're somebody who is looking to apply for short-term disability or to apply to long-term disability because you have, under the definition of the policies, you would have a disability, then the first place to start is the policy plan itself. So if, because in your case, the company has a short-term disability policy plan, then there should be something in writing. There should be a document that sets out under what circumstances you get benefits. As I said before, in order to qualify for disability benefits, you usually have to meet the definition of what a disability is. And depending on what the policy says or what company you work for, the definition of disability may change slightly. But usually all that's really required is that you have some condition. It could be a pre-existing condition. It could be something that happens that's a new development. But normally it's something you have, a condition that prevents you from being able to perform your job, or at least from being able to perform the vast majority of your job. If that's the case, then normally you would qualify for a disability. There usually isn't this differentiation between a pre-existing and a new condition. For example, you may have had a pre-existing condition that was dormant for a while, but that flared up after you started working for the company. Just because you may have had it beforehand doesn't mean necessarily that you don't qualify for short-term disability benefits. So without more information, because that's pretty much as I can tell you right now. Again, I would like, in David's case, tell you to give us a call. We would want to look at things like the short-term disability policy plan. We'd want to know, exactly why you're being refused those benefits. And then from there, we can go forward on it, because you may have a case against the company, but you also may have a case against the disability insurer. A lot of times companies don't administer their own disability policy plans. You've got people like Great West Life, Manulife, etc. And so you may actually have a case against that particular insurance company for denying you benefits. And that's something that this firm can also assist people with, is the unreasonable denial of short-term and or long-term benefits. So give us a call, but thanks for your question and your issue. I think much like David's, it raises an important one that needs to be addressed. So thanks again. Moving on, excuse me. I've got a question in from Sherry on Facebook. Sherry is asking whether or not workplace harassment or bullying would be considered an unsafe work environment. So thank you, Sherry, for your question. Definitely workplace harassment and bullying can 100% contribute to an unsafe work environment. Just going back a second, employers are obligated to provide a safe work environment, under things like the Occupational Health and Safety Act and other laws and other legislation. They're obligated to provide a safe working environment. And included in a safe working environment is essentially a work environment that's free of workplace harassment and bullying. So if somebody is being subjected to workplace harassment or bullying, number one, there should be a policy that company would have that would address the steps to take in that kind of a situation. It's required to have, for example, an anti-harassment policy. And so there are certain things, excuse me, that companies need to do in order to stay in line with the legislation. So you'd want to look at that policy. Normally, you're going to have to, of course, report the harassment or the bullying to an individual. A lot of times that happens to be your actual manager. And your manager a lot of times is the person that you're supposed to be reporting the bullying and harassment to. So I definitely wouldn't suggest doing that in that case if that were in fact the case, but there may be an alternate person you can contact. So I think you've got to raise your concerns first and foremost and sort of lay out, what the issue exactly is. Sometimes people are harassed or what they believe to be harassed in the course of their work that may not actually be an example of harassment. It may instead be an example of, maybe being overmanaged by their manager. which in a way could be harassment, but the point being that not everything is necessarily harassment. So you want to make sure you, again, revert to the policy, look at what it says, and voice your concerns, and more importantly, record your concerns. Put something in writing, send an email. Make sure you're making notes while things are going on, so that if you need to rely later on those notes, or maybe your memory is not as good later on, you can go back to those notes. I think that's always an important part. And that's as much as you can do, is report the issue to your employer. At that point, your employer is going to be obligated to look into the situation, because again, they've got that duty to provide a safe work environment, and they may have to do a fully fledged investigation depending on the nature of the complaint, depending on how many people are involved. But if that's the case, then that has to be the case. Again, that's generally their obligation, and they're going to have to address that situation, take it very seriously, and provide the complainant, whoever originated everything, ultimately with the outcome, to get a sense of what was done. And a lot of times, unfortunately, companies don't conduct these investigations in the best way. A lot of times there's a lot of bias involved. Certain factors, certain things aren't considered. So you may actually have an investigation done, but it be faulty, that it be vastly insufficient in some manner, and that too can be an issue for the employer, and actually result in an unsafe work environment, or at least promote an unsafe work environment. So depending on how the employer responds to the concerns, to the complaint, I would say take it from there. But there could be some issues after that point that you want to be aware of, because at the end of the day, if you're an employee and you're being subjected to workplace harassment or bullying, and nothing's being addressed, or it was addressed in a very insufficient manner, as I said, then that could actually result in a constructive dismissal. At the very beginning of today's session, I was talking about the definition of constructive dismissal. And one form of a constructive dismissal is where the employer sort of condones and or promotes a toxic work environment. So it's one thing for it to happen in the workplace, but it's entirely going to be, or at least mainly going to be, dependent on how your employer responds. And depending on that, as I say, outcome, you might have grounds for a constructive dismissal, and you may actually be able to leave that company as a result of the employer's sort of failure to accommodate or failure to investigate, or maybe just because the employer flat out dismisses your concerns. You may now have an option to leave and be entitled to damages as though they let you go, on top of potentially other damages for the breach of the duty to provide the safe work environment, and potentially other forms of compensation. So it's a very serious thing that needs to be treated seriously. And when it's not, the employer a lot of times is going to be exposed in a very substantial way. But Sherry, I appreciate the question. Again, it touches on a very important topic overall. Sorry, everyone, just trying to get through everyone's questions. I've got another one from N. Stinson on YouTube. This person is a remote office worker since the beginning of the pandemic. The employer, this person is saying, signed a letter saying they were a fully remote worker last year. And now somebody in the company complained, in our last hands-all meeting, that some employees get to work remotely and others don't. Okay, so there was a shift, it seems like, to working remotely. You worked all of last year remotely, and then some people started complaining about some working remotely and others not. And Stinson's wondering if they can claim constructive dismissal if the employer asks them to come back to the office 1 or 2 days more per week. So again, this is a good question. I know a lot of people are in this boat where they were working from the office before the pandemic, and they were not working at all remotely. And they then worked remotely, after the onset of the pandemic, and everything was fine. They could do their job, and now they're being asked to potentially go back in. Now, unless you have something signed that says you can work remotely for the indefinite foreseeable future, or you have some contract that you signed that says you are a remote worker, it's going to be more difficult for you as an employee to keep working remotely from home. Even if it was the case for 2 years or 2+ years that you've been working from home, If it was that before the pandemic, you never worked from home and that you have a contract that says you're supposed to be typically in the office and your employer now wants you to go into the office, you may very well be putting yourself at risk of quitting, or at least being seen to have quit, if you do not go back to the office 1 or 2 days a week. It doesn't necessarily have to make the most sense, but your employer, right or wrong, generally has the ability to recall employees back to the office, even ones that have been working from home for the last 2 years, so long as there's not a contract that you've signed that says, or some sort of document you've signed that says you will be working into the future as a remote worker. Now, Stinson mentioned that there was a letter that was signed by the company saying he worked fully remotely last year, but it seems like that just confirms the nature of his work for that year. It doesn't necessarily confirm the nature of the work going on into the future. I may be wrong. You might actually have a letter that says you're able to work 5 days a week from home from now on. And if you do, then you would have a bigger claim for constructive dismissal if they ask you to go back to the office. But if you don't, then it's going to be more of an uphill battle, and you want to definitely be careful before just telling your employer you're not going to go back to work, because you may risk them coming back and saying, well, now you're breaching your contract with us, and kind of get into a sticky situation there. So I would say, Stinson, to give us a call. This looks like a situation where, there's some current communications going on, and you just want to make sure that you're communicating again in the proper way, that you're not saying anything that might come back to haunt you later on. Yeah, like I say, we'd be happy to take it from there and just make sure you're protected as best possible. But hopefully that answers your question. I've got another question. Sorry, actually, I missed, from Rocket on YouTube, who's asking whether or not a prospective employer can ask you to fill out an extensive application form asking for your SIN, date of birth, and other personal information before an interview without hopes of getting hired to begin with. And Rocket, I would say it generally would seem a bit odd to me, for an employer to ask for that information before the interview. Normally, as I'm sure you appreciate and others appreciate, the SIN number and the date of birth and some of that other information is going to be more relevant probably following an interview, once they're sort of considering now you as a serious candidate, for purposes of filling out maybe benefits forms, or depending on the job itself, running a criminal background check, that kind of stuff. So Rocket, it does seem a bit strange to me to ask for that information up front before the interview. One thing I would say is ask them why they need that before the interview, given sort of what I've said about the whole, I think, purpose behind asking for that information. I'd be curious to know what they say. I wouldn't want to generally be giving out, more sensitive information to people in an early stage like that. There might be some concerns on my end about that in terms of what they're going to be doing with that information. So I would be very careful with that. And ultimately, if it didn't sort of add up or make sense, or there was too many red flags, I'm not entirely certain I would, give that information in advance of an interview. It just seems a bit unusual to me. And the last thing I would want is to, put my own information in danger. So I would just ask them why they need it. First of all, I mean, there may be a reason I'm not thinking of, but failing that, I wouldn't necessarily be the most comfortable in divulging that. So hopefully that answers your question. But I was just going to say, with that, I was going to let you guys go, but Stinson's just commented again saying that they have an official letter in the HR file saying that they can work indefinitely, fully remote. So I would say get a copy of that letter. If there's something signed by you saying that you can or have that ability to work indefinitely or fully remote, that's going to be a strong piece of evidence. And I would want to make sure that I get a copy of that if my employer was asking me to come back, because I would then just simply point to that document and say, the expectation going forward now is that I'm working from home. So do that. But if there's still pushback, give us a shout, Stinson, and we'll go from there. I appreciate there may be some other questions that haven't come in. I just have to let you guys go. That's my time, unfortunately, for today. But you can join Lior Samfiru this Wednesday at 1:00 p.m. Eastern, and he would be happy to try and I'm sure answer as many questions for you as he can. It's noted down there below, 1 p.m. Eastern. So tune in, get your question in at the top of the hour, the half hour then. And otherwise, hopefully I'll see all you guys later on next time I'm around. And again, I'll look forward to doing that and answering all your questions. But thanks for tuning in. Thanks for joining us, and have a great rest of your day.